afternoon, everyone, and welcome. Thanks for braving the rain and the flu and all the other things that are happening these days out there to come and join us today. We're really glad to have you here. So, we are here today to celebrate the work of our faculty fellow Richard Thompson Ford and to enjoy our Chautauqua experience, which is supposed to be informal. So please say hi to your neighbors, get up and during the event, get some more coffee, get another glass of wine, but also very discussion based. So we're going to have a nice chance to really engage after we hear some opening comments about the book and Professor Ford gives his comments to really get in there and engage in detail about his book. So please, talk, feel free, and be comfortable in our space. So before I turn it over to Dara Strolovich, she's going to be our moderator for today's event. I'd like to acknowledge our other faculty fellows this year. In the fall quarter, we had our first Chautauqua with Hazel Rose Marcus. She's David Sprack Professor in the Behavioral Sciences from the Department of Psychology. And she was in conversation with Prudence Carter, our Research Institute Director, about her recent book, Clash: 8 Cultural Conflicts That Make Us Who We Are. And then we have in May our final Chautauqua of the year in the spring, and we'll be honoring Professor Corey Fields. Corey is Assistant Professor of Sociology in CSRE, and we're going to discuss his new book manuscript. So this is a preview before it even gets out there into the world of his new book called Black Elephants in the Room: Race and the Unexpected Politics of African American Republicans. So I hope you can join us on May 1st to celebrate Corey's book as well. So before I turn it over to our moderator, I'd like to introduce Professor Dara Strolovich, who is a visiting scholar this year. So we have the honor of having her join us for the year here at CCSRE. And she's also a visiting scholar at our affiliate institute, the Institute on the Politics of Inequality, Race, Ethnicity at Stanford, otherwise known as INSPIRE. So of course we got to have our acronym in the Stanford environment. So that's a pretty good one. And she's joining us. She's going to be starting a position at Princeton University next year, and she is Associate Professor of Gender and Sexuality Studies and also affiliated faculty in the Department of Politics. And her interdisciplinary research explores the politics of marginalization in the United States, focusing on the interest groups and social movements, political representation, the causes, constructions, and consequences of political inequalities, and the intersecting politics of race, class, gender, sexuality, and enduring structural inequality. And her award-winning book called Affirmative Advocacy: Race, Class, and Gender in Interest Group Politics addresses these issues by examining the extent to which and the ways in which advocates for women, for people of color, and for people from low-income contexts represent what scholars have come to call intersectionally disadvantaged subgroups of their constituencies. So really thrilled to have Dara participate in our community this year. And as you can see, she's a great fit for tonight's discussion. She's going to help us stir the pot a little bit on these topics. So please join me in welcoming her, and she'll introduce our speaker.
Thank you so much for that incredibly generous introduction, Mariam. And also really for inviting me to participate in this event. It's really an honor and a privilege as a visitor among you to have the chance to do this kind of event, and really to talk with Professor Ford about his provocative and engaging book. And it's also a privilege and a pleasure to have the opportunity to introduce your colleague to you, which is sort of a funny thing to do. But hey, who, as many of you know much better than I do, as a consequence of the fact that I'm meeting him for the first time today, is the George Osborne Professor of Law here at Stanford, where he also earned his BA before going to get his JD at Harvard Law School. Before joining the law school faculty, he was a litigation associate with Morrison & Foerster, a housing policy consultant for the city of Cambridge, and he continued doing some of that kind of public engaged work, moving to the Bay Area, where he served as a commissioner of the San Francisco Housing Authority. As most of you know, he's an expert on civil rights and anti-discrimination law, and a really, after reading this book, come to think, insightful and compelling writer on and scholar of issues of race, multiculturalism. He's written or edited a humbling number of books, 6, I think, and an even more humbling number of articles and book chapters. I think I counted up to about 24 or so. and on a even more humbling range of topics, widely ranging from things like the social and legal conflicts surrounding claims of discrimination, the causes and consequences of segregation, and the use of territorial boundaries as instruments of social regulation. And in addition to this academic scholarship, he also writes for popular audiences. Some of you might know he's a regular contributor to Slate, but he's also written for the Washington Post, the San Francisco Chronicle, and the Christian Science Monitor. One of his two most recent books is Rights Gone Wrong: How Law Corrupts the Struggle for for Equality, and that's what we're going to be talking about this afternoon. So as I've said, it's really exciting to be able to have the chance to discuss this excellent book with you and with Professor Ford, since I've been told to assume that everyone's read at least some of it. Yeah, okay. Rather than trying to do justice to the many complex issues and provocative ideas that it raises in the few minutes that I have, I'm going to take a few minutes now to begin by flagging and then raising some questions about what strike me as some of its sort of signature contributions and some of its central and I think most provocative arguments or thought-provoking arguments. And I'll then turn it over to Professor Ford. He will speak to you about the book and then have a chance for some questions and discussion as well. So first, what does Ford, and I hope I'm representing this properly, mean when he claims that rights have gone wrong? And as I read it, the book is kind of a, if you'll excuse literally my French, a sort of cri de coeur, I think, from a scholar, activist, and advocate who cares deeply about and has long been involved in pursuing justice and equality, and who sees civil rights, which have long been considered the central tools and the main hope for achieving these goals, becoming at best watered down, and at worst probably irreparably hijacked and distorted in ways that are actually making things worse for the very groups they were supposed to help. And in this book in particular, people of color, women, and people with disabilities, among others. And so his arguments really kind of draw on and also are in conversation with work, as he notes, of critical legal and critical race legal scholars, but also with political theorists and scholars of gender and sexuality, race and ethnicity, increasingly disability studies, who address these issues in different but sort of overlapping ways and critique rights discourse in the US and other liberal democracies. So Wendy Brown, for example, a political theorist across the Bay, argues rights discourse in liberal capitalist culture casts as private, potentially political contests about distribution of resources and about relevant parties to decision-making. It converts social problems into matters of individualized, dehistoricized injury and entitlement, into matters in which there's no harm and if there is no agent and no tangibly violated subject. Ford's particular take on this issue is simultaneously straightforward, I think, but also subtle. His concern is that, and these are his words, when it comes to outright discrimination and overt prejudice, civil rights have been an astonishing success. But he continues, many of today's most serious social injustices aren't caused by bias and bigotry. As he puts it, civil rights do too much and too little at the same time, too easily hijacked by opportunists or by special interests, demanding privileges, who push radical schemes despite democratic opposition, and in some cases, even to reverse and undermine the social justice goals civil rights were supposed to achieve. So as you can probably tell by the pads worth of Post-it notes that have now come to populate the pages of the book, these arguments and his analyses really got my wheels spinning, the wood burning, however you want to put it, and prompted many reactions, but I'm going to focus on a few clusters of reflections, observations, and questions, many of which stem, at least in part, from my disciplinary perspective, which I was told to use as a social scientist, and more particularly as a political scientist who studies, as Mariam suggested, the intersecting politics of race, class, gender, and sexuality in the US. But I should also add, because it's going to become obvious soon, they also stem a little bit from the fact that I'm Canadian. And I sort of bring a little bit of a comparative perspective to my thinking about American politics and policy and law. Warning. So the first set of reflections, I think, I would say, are perennial ones that almost inevitably surface anytime a legal scholar and a political scientist are put in a room together. So I'll just kind of put that one out there to get it over with. So one of the wonderful things about the book is Ford's talent for giving readers a fresh perspective on long-standing issues and debates, and really zeroing in on an increasingly frustrating set of problems for politics, policy, and the law. And he does this in part by using provocative examples that really illustrate the problems and allow him to really articulate an analysis of them that really drives home the paradoxes and, I think, conundra of using the law and civil rights in a context of what Cathy Cohen calls advanced marginalization. But although some of the cases, like the Seattle and Louisville school desegregation ones, seem really to have indisputably broad implications, and in that case, essentially holding that the Brown decision prohibits rather than mandates attention to racial inequalities in public education, in other cases, and here's the social sciencey, I wondered how representative and generalizable, yes, I use those words, the last refuge of social scientists, those kinds of cases are, and what we might see differently if we kind of pulled the lens back a bit. So for example, the Hooters, Ladies' Night, and Mother's Day cases seem pretty clearly to be distortions and, at best, trivializations of real problems associated with sex and gender, but brought by men who want to claim a version of reverse sexism. But I started to wonder sort of what proportion of sex discrimination cases in general, and successful ones more specifically, are like those. And what proportion are either real grievances that need some kind of adjudication, or cases where it might be a man bringing the case, like the On-Call v. Sundowner, and I'm getting a little bit out of my depths here, but I know that case, in which sex discrimination is used by a man because it's the only tool available, because other rights or injuries have yet to be recognized, and in that case actually affirms a version of sex and gender issues that injure men, at least in my understanding, in ways that we would or we might want to recognize if we're trying to create a more just and equitable society along lines of sex and gender. Another place where I wondered about what the social scientific literature might have to say was less about a particular case or set of cases, and more about the sort of characterization of the problem. So you write, for example, and these are a quote, "The civil rights tradition encourages us to look at disputes through a lens that is designed to focus on discrimination. But today, racial injustice is much more complex. Formal race discrimination is rare, and the effort to shoehorn problems such as residential isolation, joblessness, incarceration, and a dysfunctional culture of poverty into the category of discrimination has made it harder to address those problems." End quote. And while the discrimination framework has clearly major limitations when it comes to addressing those problems, especially if, as you also discuss in the book, we're not allowed to talk about race anymore in addressing racial inequalities, I wonder whether they really can be separated from those problems. And so I wonder how you think of how your claims relate to a growing body of sort of large-scale studies that show that essentially that unsubtle, unambiguous race and sex and other forms of discrimination persist, and that they actually play a pretty clear explanatory role in all kinds of disparities, right? Job discrimination, car sales, housing loans, rentals, teaching evaluations, one that's close to our heart, and also in healthcare, in things like cancer screening, cancer treatment, heart disease screening and treatment, et cetera. The other thing I wondered a little bit about was that since you're interested in race and gender and sexuality and disability, which was really one of the things I loved about the book, was that it sort of tried to be pretty holistic about things. I also wondered how you think about, or if you think about your arguments in relationship to intersectional and critical race feminist scholarship developed by, I probably don't need to tell this crowd, scholars like Kimberly Crenshaw and Cheryl Harris, who have lodged what I think of, not surprisingly given your introduction, some of the most powerful critiques of legal reforms and civil rights that focus on punishing individual discriminators for what Crenshaw calls single-axis issues. Since one way of thinking about, or another way to put this was one way to think about some of your concerns is that civil rights fail to help people who experience multiple vectors of subjugation, who face unique harms that aren't captured by the single access laws that address only race or only sex or only disability, but some of those in conjunction with each other or with poverty, for example. Another cluster of questions that I was hoping you might discuss has to do with the causal power that you ascribe to rights. Again, social science, they told me to be one. And whether you can isolate rights themselves as the root of the mechanisms that you describe. And a few things come to mind here, and here's where the Canadianness comes out. So thinking comparatively a little bit, the US isn't the only country that's come to rely on legal and rights-based approaches to issues of injustice and inequality. And certainly we could lodge a lot of critiques, and many critiques have been lodged against the rights-based liberalism of mostly Anglo tradition countries, but others as well. But comparing the US to some other countries suggests that at least part of the problem isn't relying on rights or legal remedies per se, but that these rights were codified in a particular context, one in which the particularities of American conservatism have been fed through elements of other parts of America's constitutional and institutional design. So federalism, separation of powers, electoral college, Senate, all things that have allowed first Southern Democrats and more recently conservative Republicans to really control the agenda and drastically truncate the ideological and policy spectrum. So one particular example of this kind of difference is that no doubt, with the benefit of hindsight, because they live to the north of the US and saw the sort of the violence done by colorblindness in the US, the equality rights laid out in the Canadian Charter of Rights and Freedoms specify much like, sort of start out sounding relatively American. So they say, every individual is equal before and under the law and has the right to equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. So a longer list than we cover here. But the paragraph following that, directly after, then specifies that those provisions do not, and this is a quote, preclude any law, program, or activity that has as its object the amelioration of conditions of disadvantaged individuals or groups, including those that are disadvantaged along all those axes, right? The constitutions, as I understand it, of India and South Africa include some similar provisions. And I'm not trying to suggest that life is all utopian in any of these places, and I have at the top of my head the fact that Quebec is, as we speak, considering a pretty hideous charter of Quebec values anyway, it's a digression, basically xenophobic, Islamophobic, et cetera. But if there were an analogous constitutional or statutory provision in the US, the Supreme Court decision, for example, in the Seattle and Louisville cases, would have been far less likely, if not impossible, right? Or we wouldn't have even gotten to the point where we were having that discussion. So is it the use of legal remedies and rights that is the cause, or that American conservatism and the structural features of American politics that I mentioned a minute ago make it almost unimaginable that such a provision would ever have been passed by Congress or added to the Constitution? And if it's the latter, then I'm also interested in how you think the kinds of reforms that you suggest would be better than the legal and rights-based remedies. And I think, if I'm understanding correctly, that would sort of be more democratically passed and implemented, whether we think they have any better shot of getting passed than the kind of second provision in the Canadian Charter of Rights and Freedoms. Another thing that comes to mind, if we think comparatively, has to do not so much with Americans having too many rights, but the kinds of rights that Americans don't have. And I'm thinking particularly of economic rights. So for example, at least my understanding is that anti-poverty lawyers tried actually to get the Supreme Court to find poverty a suspect classification and failed, right? They basically were thrown out sort of time and time again. But how might things be different if they had? Would that be the kind of right that might sort of work in conjunction with these other rights to be a more robust framework for social justice? I know it's all a little bit fantastical, but I just wonder if, if the problem is not necessarily too much, but the wrong kind or too few or something like that, or the wrong combination. Or if the New Deal policies that codified racism and gender traditionalism of Southern Democrats instead had actually been progressive on those counts. Or in a more recent example, if instead of imposing a mandate to buy insurance, and this is totally fantastical, right? The Affordable Care Act had actually instead codified the idea that Americans have a right to health care, which sounds crazy, but other countries do have that kind of language. It's a little bit of an aside, you're not really talking about health care, but those are the kinds of rights Americans don't have that I think make huge differences in how rights are the rights that do exist are sort of implemented and distributed. And again, sort of suggest that the problem might not be rights themselves, but a kind of conservatism and neoliberal resistance and destruction of anything that looks like a safety net, increasingly. And then finally, I think one of the most striking, and this is a bit of a change of course, striking and exciting things about the book is that, to my mind, it really exemplifies a commitment and ability to convey these really complicated issues, I think, to a popular audience, and not necessarily in short form, but in this case in long form. And I think this is something that many of us aspire to do, but at least something that I know I've had a hard time doing or have a hard time doing and I find challenging. And I'm sure I'm not the only one, although I don't want to presume too much. So I'm hoping that you also might talk about what this process is like for you, both in sort of writing the book and also in your other public engagement in popular writing. So what kind of decisions do you have to make about the evidence you use, about the way you present evidence, about the kinds of arguments you make and the terminology? These are all sort of mundane, but I think very interesting in sort of thinking about how to present this kind of work to a broader audience. The one that I have to admit sort of struck me is that for those of us who aren't legal scholars, anytime you go to a legal journal, it looks like all there is footnotes. And I wonder how hard you had to restrain yourself because it was remarkably Spartan on that front. It was sort of refreshing as a legal text. So I will end there. I don't want to take up any more time. I know Rich has a lot he wants to talk about, and people probably have many questions. It's really just the tip of the iceberg. So I look forward to hearing your presentation and everyone else's thoughts and questions.
Well, thanks so much. I honestly, I don't know that I can do better than this synopsis. Really, they were great questions. And sometimes people say those were great questions because they know they have answers to all of them. I don't know that, but I think they're absolutely the right questions. And so I'm going to take a slightly different tack than I had planned to take, which is not to summarize quite as much, but to summarize a little bit and spend more time trying to engage with some of the really thoughtful questions that we've heard. So I'm not sure where to start. I want to talk about On Call, but I'm going to have to leave that probably till the very end because we'll need to summarize. The basic idea. The basic idea behind the book, if I could say one, you try to crystallize it into one sentence, is that rights have gone wrong because they've occupied the field of thought and policy and imagination around questions of social justice. And when I say occupy the field, that's a little bit of legal jargon. When a federal law is passed and it pushes out all attempts for state and local laws, it's written in such a way that it says you can't have any legislation in this area. That we say that law has occupied the field. And I think civil rights have done this particularly in the American context, but I fear that they threaten to do it internationally as well. And I want to talk a little bit about international rights and rights in other national contexts along that line. But they've occupied the field such that they are the only way we can think about dealing with questions of inequality, with questions of marginalization, with questions of widespread social contempt, a whole range of questions which in order to be effectively addressed, have to be dealt with through much more comprehensive policies, broad-based institutional changes, and in ways that frankly are going to require significant compromises, not only compromises on the part of those who we might consider to be our ideological enemies, but compromises among values that people, we might say people on the left hold dear. And that the necessity for comprehensive change and for significant compromise among incompatible policy judgments is elided by the description of the policies in terms of individual rights that are absolute, at least in their mode of articulation. So if we say, and that's why I gave the Ladies' Night example, I would, to some extent, I would agree that the Ladies' Night example is not representative. But I do want to suggest that it's not entirely trivial that there are attorneys who make their living bringing Ladies' Night style litigation. In the state of California, Ladies' Nights and various promotions like that are unlawful, and there's a statutory fine of, I think it's $4,000 or $5,000 per occurrence. So if you're running a nightclub and you have Ladies' Night, and it could be $4,000 for every man that walks in the door. That's a pretty good living, and so it turns out that this litigation is out there, and it does stymie sensible policies that are designed to recognize real issues that women deal with. So, for instance, in some states, people exercise gyms are sued for having separate or quote unquote segregated men's and women's workout areas. When I think that the practical justification for that is relatively obvious, and at any rate, it strikes me as the kind of issue that ought to be decided either through the market process or through the democratic process, and not decided by courts applying abstract legal norms. So when one confronts the litigation around things like Ladies' Night, part of the idea is that the courts, in confronting these questions, all too often confront them as if there's no room for judgment about the policy in question. So Rose Bird says the legality of sex-based price discounts cannot depend on subjective value judgments about which kind of sex-based distinctions are important or harmful. And this idea is sufficiently widespread in the legal discourse that to some it's kind of synonymous with the rule of law. When one adopts that idea, the result, when applied widely, is there's another potential example, but the result, when applied widely, is the much more corrosive instances that I described in the book. For instance, the parents involved case where the principal at issue in Brown versus Board of Education is then redeployed by the court to say that an effort to integrate the schools violates the Constitution. So you have Robert Carter, who argues in Brown versus Board of Education, no state has any authority to use race as a factor. Obviously, Robert Carter did not anticipate that blocking an effort to desegregate the schools, something that was probably hard for him to envision in 1953 and 1954 when the case was litigated in front of the Supreme Court, and yet it's thrown back in the face of civil rights advocates later by John Roberts. It turns out John Roberts didn't know that the lawyers that litigated Brown versus Board of Education were still alive, Robert Carter in particular. So the next day people interviewed him and said, "Is that what you meant?" And of course he said, "Hell no." But the legal logic is consistent, even if the moral logic and the policy logic is bankrupt. And so the faith that one can adopt a strict and rigid legal rule that will protect you from politics and that will protect you from market forces and that will protect you from your fellow citizens is, I think, is a false faith. But it's one that encourages people to embrace this type of logic. So Rose Bird embraces it in the context of Ladies' Night. I suspect, in part because of a conception of her role as a judge, which precludes making value judgments, but in part, I suspect, based on a conception that rights need to be absolute in their mode of articulation and implementation in order to do their job. And if that's right, then you're stuck with parents involved. I think that there's a better way. And the better way is the judges, as their name implies, make judgments. That's their job, actually. And if they don't want to make judgments, they need to find a different job. But the necessity of making value judgments and defending them would perhaps give us better results. That perhaps it would be better if John Roberts had to explain why it is he thinks it's not a good idea to have policies that desegregate the schools in Seattle and Louisville, rather than simply saying, Robert Carter thought it was a bad idea, the Constitution says it's a bad idea. I can't make, I can't tell the difference between a policy that's designed to promote racial inequality and one that's designed to remedy it. And this is the position of many of the people on the court who've consistently voted against ameliorative race-conscious measures. But there's more. I also want to suggest, and this kind of gets us to the question of whether the problem is conservatives hijacking rights or the problem is rights themselves. That to some extent I do think that the problem is rights themselves and not just conservatives. Certainly conservatives hijacking rights is a problem. And I have no doubt that there was a concentrated, calculated effort to deploy the principles of the civil rights movement against the practical goals of the civil rights movement. There's no doubt about that in my mind. But it does seem to me, one, we leave ourselves vulnerable to that type of attack by using a tool that's so easily redeployed against its purposes. And that's the way rights articulated in the way they are in the American civil rights tradition function. When one says, I have a right to be free of race discrimination, and that's the extent of the articulated legal entitlement, then it's built in that would be deployed against race-conscious ameliorative measures, and shouldn't be a huge surprise when it happens. Now, what's a better way? One consequence, I actually need to say a little bit more about the problem of desegregation. So after Brown versus Board of Education, you had an attempt to desegregate the schools and a struggle over what it meant to desegregate. Whether desegregation meant Southern schools just quit saying that you've got a black school here and a white school there and you're done, or whether it meant something more. Ironically, foot dragging by Southern school districts led the courts to have 10 years to notice all of the ways that Southern schools tried to look like they were desegregated and actually not doing it. So you wound up with much more assertive measures than you might have had to confront the attempt to avoid desegregation. And that included busing, which was in many instances necessary, but also extremely controversial and often mismanaged. And the mismanaged part is important to zero in on because courts aren't in a very good position to manage things like pupil assignment or the political and social conflicts likely to result when students are reassigned across socioeconomic, racial, and neighborhood boundaries. But courts were kind of forced into that position without adequate institutional resources and, in many cases, without adequate expertise or knowledge of the underlying problem. And one of the difficulties in that movement of desegregation was that in many cases, civil rights lawyers didn't want to listen to the people on the ground because they understood desegregation to be a bedrock constitutional principle. Derek Bell, a civil rights lawyer who worked on many of these cases, and later, as I'm sure you know, taught at Harvard Law School, and then at NYU Law School, wrote compellingly about the problem of the failure to compromise or the failure to work through alternative approaches to dealing with school segregation and inequality. And the result was things like what happened in Boston, where school buses were, people threatened to turn over school buses and set them on fire. The degree of hostility was so profound that it was impossible that anyone was getting an education. And the backlash was so severe that eventually just about everybody at least tacitly understood that the courts had to back off. And so they did back off. They backed off in the context of Detroit, where in order to achieve a desegregation remedy, you needed to include the suburbs. The city had become something like 92-3% black. The Supreme Court eventually said, well, we can't include the suburbs, and therefore there's no effective remedy. So we've got the right on the books, the right in theory, but in practice, nothing is happening. One of the things I want to say, and this has been a case that's frustrated me since I began my legal career. It's probably one of the reasons I became a law professor practically, was to write things against Milliken versus Bradley. It so infuriated me as a law student. One of the things I've come to think over time, however, is that by the time you got to Milliken, it was probably inevitable that that's what you were going to wind up with. What's the alternative? Well, the alternative would be that we turn over, and this is what one of the district court judges in the early desegregation case suggested, you turn it over to administrators who have some competence in school administration. Now, of course, there's a problem. Can you trust the administrators? In many instances, the answer was no. But it is worth noting that the Department of Education backed the desegregation mandate after the Civil Rights Act of 1964, and that's really when things got going with desegregation. Not Brown, but the Civil Rights Act of 1964. Not courts, but legislatures and legislation through the democratic process. And that might have been an opportunity to build a more robust administrative apparatus that could have figured out how to get this done rather than just leaving it in the hands of litigation and courts. And might have given us better results. We all know, or people who are study this area know, that today the schools, America's public schools, are de facto remain segregated, and in some cases are as bad as in the era of Jim Crow. So although Brown versus Board of Education is held up as the greatest victory of the civil rights movement, in the area where it was meant to have its effect, the practical consequences are not so impressive. Maybe there'd be another way. But it would require comprehensive institutional reform at a level of detail and at a level of sophistication that, frankly, I think courts and even negotiated settlements between litigants are generally incapable of. I could say a little more about that in the context of employment. So some of you may have heard of the case Dukes versus Walmart, huge class action, obvious that there's a lot of discrimination. So to return to your point about the various studies that demonstrate that discrimination is still a problem, yes, absolutely. Problem, however, can't tell where. And this is a consistent problem in civil rights litigation, that there's a lot of discrimination out there somewhere. You can't explain the disparities in any other way except by reference to race or by reference to sex, but you can't tell who's discriminating and who's been discriminated against. And a consequence of the rights-based approach is that very often you need to be able to show that. Dukes versus Walmart, and I don't want to get into the weeds of class actions and class certification, but one shorthand way, and only slightly distorted shorthand way of putting this, is that the court wanted to see a policy that joined all of the Walmart stores together, to say that Walmart as a corporation was comprehensively responsible for the disparities. And so instead what the court found were widely divergent claims. One woman says she's a victim of sex harassment. The other says that she was denied a promotion she deserves. Another says that the whole promotions process is a boys' club. They're different. They're in different parts of the country, different managers. We can't tell whether these are isolated incidents that you ought to prove individually or one big one. And guess what? When you try to prove them individually, you're going to have a very hard time doing so because Walmart says, well, you know, how do we promote people? Is there a test? Is there a numerical measure? Is there some way where you could actually tell whether the person who deserves the promotion gets it? Well, no, not exactly. What we have is a policy where the lower level management makes the decision and no one else wants to hear about it. Complete discretion in the lowest level. And they're told to consider things like team spirit and integrity. So when you sue, they say, well, you know, okay, it's true that the woman had more experience and, you know, seems better on paper, but the man had more integrity. And so we gave him the promotion, and that's lawful and it defeats your claim. So how would you fix this problem? One idea, I think, and here's the compromise, we'd suspend the commitment to individual entitlement. If you take a case like Walmart, the proposed class action approach of the trial court, who was willing to go ahead with the litigation, was, look, what we're going to do, we're going to evaluate just how bad the discrimination is. We'll hear Walmart's rejoinder to the statistical evidence of disparity. We'll figure out whether or not there's a real discrimination problem. And if there is, Walmart's going to pay a fine based on every incident that we can figure out with statistics. Then we're going to figure out how to divide up the money in phase 2 in which Walmart's not involved. So it was a kind of a rough justice idea, and the people against class certification made a lot of this. Like, look, you know, you're going to divide the money later according to a formula, and you don't. If some of the women don't have a valid claim, you have 1.5 million women. Some of them don't have a valid claim at all. Some of them were lazy. Some of them were not good workers. They're going to get a portion, and then the ones that really suffered are going to have their recovery diluted. It's not fair. It's not fair to the individual, but it's rough justice is better than no justice, which might be the alternative. So, what if we did this? And I'm just going to round out the discussion with one example involving employment. In 1964 or 1963, when the Civil Rights Act of 1964 was being debated in front of Congress, a proposal was that you would have the federal agency that's charged with enforcing civil rights laws, the EEOC, and that would be modeled on a more robust administrative agency that would have cease and desist power and the power to issue binding regulations. So it would be more like the Environmental Protection Agency, where if your practices aren't up to snuff, the EEOC could just come in and say, you know, you need to fix these practices, and you've got 90 days to come into compliance. Now imagine if we had that, and that kind of organization could confront Walmart and say, here's what we see as a problem, here's your timeline for fixing it. If you don't fix it, you're going to face fines, rather than doing it through individualized litigation. That might be better in any number of instances. There would be compromises, and no doubt there would be some people who had valid individual claims who would suffer discrimination and not have a remedy. But my suggestion is that we would have better results for the many, many people who don't sue, can't be bothered to sue under our individual rights framework, and that kind of comprehensive reform could get us better results, particularly today when so many of the cases that we're looking at are ambiguous. And what I mean by ambiguous is not that we're not clear that there's still discrimination in society, but that they're ambiguous in the sense that we can't tell when. We can't be sure whether that person was a victim of discrimination or not, or whether the real discrimination is going on somewhere else. And most of the examples that I give in the book are cases like that, cases where the claim of discrimination is made and it's plausible, but there's also another plausible explanation. And if the burden of proof is with the plaintiff bringing the case, the plaintiff is likely to lose that case. But in addition, we create a distorted idea in the court of public opinion, if you will, about the nature of our social problems. And so you come back to Wendy Brown's quote, and Wendy Brown is one of my inspirations for thinking about these questions of rights in this way. But Wendy Brown's idea that if there's no individual victim that you can point to, then there's no problem. And I'm afraid that's where we're headed today. So I wanted to say just a little bit more about rights in other national contexts and whether the problem is distinctive to the United States. And I think certainly some aspects of this problem are unique to the United States. But it does seem to me that in many instances, this also goes to the question of economic rights and whether the problem is not too many rights but too few, that we confront a similar, though not identical, problem when we try to expand the category of rights to positive entitlements. Because in that context, and I'll give you a specific example. Suppose you say that people have a right to food. There's been a big right to food movement internationally. What that does not tell you is how the people are going to get the food, who's going to produce the food, who's going to distribute the food, etc. All of the details necessary to actually getting food in people's mouths are not contained in the statement that the person has a right to food. And so maybe they're implied and maybe not. But if they're implied, the implications might not be good policy. The example that I'm familiar with, so you say there's a right to food in India, where a large, scandalous percentage of the population is malnourished or starving, even in a context in which there's lots of food being exported and food in some cases rotting in silos that can't be distributed. Now, okay, let's suppose we said that. How are they going to get it? Well, the answer is probably the default answer in international human rights is that the state has an obligation to fulfill the right. But the state is the problem in this context. The state has been working and in various ways failing to administer a food distribution system in India for decades. So it's not clear that saying that there's a right to food is going to fix the problem. It might actually make it worse unless it's accompanied by a fairly detailed policy that confronts the difficulties and figures out how you're going to actually get it done. And that, I fear that viewing these issues in terms of rights moves us away from the policy discussion rather than encouraging us to have it, a policy discussion that in many instances may involve, again, compromises and may also involve surprising findings about what would actually work best in order to achieve our collective goals. So I think there's no way around politics. There's no way around fighting it out with people who may be your ideological enemies. And my worry is that, in the words of I'm going to forget his name, a really interesting historian from Columbia, Samuel Moyn, that human rights have become the last utopia, that rather than thinking through problems in a comprehensive way and asking what our values really are in society, it's become sort of the last default utopia. And the reason it's endured as a utopian idea is precisely because it's without content. And so you don't have to figure out or deal with the complexities of social organization, of distribution and distributive justice, and what have you. You can just say somebody has a right. I'm very dubious that that's going to be an effective way to confront the difficult social problems of today. Okay, so I'm done. Thanks.